The inquiry returns today after the issuance of the Chamber directions on the 31st to the 3rd to the 5th, and now we're sitting on the 6th of April 2023. These specific Chamber directions are included in the direction itself that give reasons why the adjournment was made. Before we go any further to that, the Commission would like to extend the condolences to the late Sir Ravi Namaliu, one of the former Prime Minister of this country, who tragically lost his life on the 31st of March 2023. And for this reason, on behalf of the Motukea Commission of Inquiry and its staff, we further extend our condolences to the immediate family members who are in mourning at this time. Those are great leaders that have took our country to where we are at the present time, and therefore we must acknowledge one of the leaders who have been the former Prime Minister of this country. That's the condolences from the Motukea Commission of Inquiry. With that, we return back today to deal with submissions that is required for this sitting this morning. But without further ado, I will now call on the Counsel to take us through this morning. Thank you, Counsel.
As you mentioned, the purpose of today's hearing is to receive these submissions of our Counsel assisting. But perhaps before I proceed, I'll allow my friend, Mr. Veritamos, to enter his appearance.
Thank you.
If the Commissioner pleases, Veritamos is my name, initials MM. I appear with my learned friends Mr. D. Wood and Mr. Alla Ivori for Curtin Brothers Holdings NG Limited and Ballymore number 39 Limited, if the Commission pleases.
Thank you.
So, Commissioner, we have emailed copies of our submissions, and various attachments we'll be referring to. Perhaps if my friend can confirm he's received my copies of my submissions before I proceed, Commissioner.
Yes, Mr. Commissioner, we received the submissions and attachments about 10 minutes ago by email. Obviously, we haven't had a chance to read them, but they've been received.
Thank you.
So, Commissioner, just in terms of what is intended to be done this morning is essentially to present our submissions in reply, and then for the matters to then be adjourned to next week, Friday, at the 14th of April, at which time the lawyers for Curtin Brothers and Ballymore will then reply. Commissioner, there's also a point in regard to the landowners, to the extent that they have expressed an intention to reply to submissions made by Ballymore. We propose that that also be set down perhaps after Curtin Brothers replies, or Curtin Brothers and Ballymore reply on the 14th, perhaps on the same day, or we'll confirm what will happen in terms of what they want to do. But that will just be limited to matters concerning the landowner applications. So that's essentially what will be done this morning, Commissioner. So perhaps if I can just proceed with the submissions, Commissioner.
Sorry, before my learned friend proceeds, given that what he's just indicated, if the landowners are going to make submissions in relation to the reply submissions on 1DDD, I would respectfully suggest that that be done before next Friday, so we have an opportunity to listen to them. Otherwise, they could make submissions and then we need to do a further reply. So I would respectfully suggest that if they're going to do submissions, they do so next week, possibly next Wednesday, but only limited to replying to quadruple D, sorry.
Thank you, Counsel. Counsel Assistant.
Yes, Commissioner. I do appreciate what my friend is saying. Given that tomorrow is Easter and Monday is Easter Monday, Commissioner, perhaps Wednesday may be a bit too tight for the landowners. Perhaps Thursday afternoon would be more convenient. I expect the submissions to be quite narrow. They were quite a narrow reply submissions that I anticipate the landowners will make. Obviously, to the extent there's any submissions that are made outside the terms of reference, those are matters that we can easily, quite quickly disregard. But I think, in fairness to the landowners, perhaps Thursday morning would be appropriate for them to present their submissions, and then Curtin Brothers and Ballymore can then present their reply submissions on Friday. Perhaps is that suitable to Mr. Vertimos?
Thank you, Counsel Assisting. That's suitable, subject to us reserving the position in terms of we don't know how detailed or what the landowners are going to say. So it might be the case that we need slightly more time to respond to what the landowners say, but I do agree with the principle that the landowners should go first Thursday morning. We can obviously we'll make every effort to deal with submissions that Counsel Assisting make. If the landowners' submissions on Thursday require some supplementary submissions, then we'll need to deal with it, and obviously we'll reserve our position.
Thank you, Counsel. In terms of our roadmap and timeline, are we comfortable with it? If Thursday is fine, then we'll settle with that. Yes,
Commissioner. So just for the record, noting that some landowners are present this morning, the direction should be to the effect that the landowner submissions in reply to be presented at 10 a.m. on Thursday, the 13th of April, 2023.
Thank you, Counsel. I now give direction that the landowner submission will be presented on the 13th, which is Thursday next week, is it? Yeah, at 10 a.m. That's the direction that I'm giving now. Thank you.
Yeah, thank you, Mr. Commissioner. And as Counsel Assisting said, they're limited to reply submissions only, not substantive submissions in respect of one quadruple D, so as long as the landowners understand that point.
Thank you, Counsel.
Yes, thank you, Mr. Vertimos. I'll have a word with them after the hearing just to re-emphasize the importance of them sticking to the terms of the reply submissions. So without further more, Commissioner, perhaps I can start with my closing submissions.
Yes, you can proceed.
Rather in reply. So, Commissioner, I've set up basically an introduction. These submissions we intend to be also published on the website, but otherwise, Commissioner, you will note at the end, right at the end there, only myself, I have signed the submissions. On page 25, Mr. Keeper is currently attending to a matter in court. He has authorized me to present these submissions on his behalf. He will then endeavor to have it signed, and signed copies can then be also circulated to my friends as well for completeness, Commissioner. So I just mentioned that for the record. Now, Commissioner, the submissions are contained in the introduction. I basically introduce the objective of the inquiry and the context in which it's been done, having regard to its establishment. You'll see at paragraph 4. We touch on the jurisdiction at paragraph 5, Commissioner, and the process entailed therein. A brief background is covered in part 4 hearings. where we basically record broadly the dates on which the Commission commenced hearings pursuant to its roadmap, and the Part 5 on page 3 deals with the terms of reference and the amended terms of reference as to the purpose and the jurisdiction and questions that arise for consideration. Now, Commissioner, we also wish to record there were detailed submissions provided by the lawyers for Curtin Brothers and Barrymore, and we wish to record our indebtedness to them to the extent that we'll be adopting most of their submissions, subject to the matters that are raised in our submissions this morning. Now, Commissioner, you'll recall in the submissions that were presented by my friend touched on or was approached from the context of the factual scenario under which the the sale and purchase of the Motukea Wharf was done. Now, we've taken a different approach in terms of approaching it from a commercial context, and we say that is important, Commissioner, in terms of understanding the transaction and in this instance, particularly the importance of the evaluation of the Valuer General of the Motukea Port, and in turn how that affected the valuation of the Port Moresby Port, which was then the subject of the loan facility, which was then entered into by IPBC and BSP to essentially bankroll the port project. So if I can just start by reading my submissions, Commissioner, just in terms of the structure, I think it's important I just set that out. Paragraph 11, Commissioner, the Port of Port Moresby Relocation Project, POM Port Relocation Project, was a major infrastructure project that resulted in the relocation of POM Port to the Motukea Port. Given this massive infrastructural undertaking, an appropriately structured loan facility was necessary to finance it. Naturally, before the loan could be secured, a valuation of the POM Port, amongst other things, was required. So I'll take you through the relevant terms of the loan agreement to explain the commercial context under which the project was undertaken. Now, Commissioner, incidentally, the role of the Motukea Port valuation came into play as it was crucial in determining the fair market value of the POM Port. This, in turn, was necessary for the securing of the loan facility, as the value of the POM Port was determinative of the amount of money that could be borrowed. So once the loan was secured, the POM Port relocation project could proceed to implementation and ultimately completion. So that's essentially the gist of our submission in terms of understanding the commercial context of the transactions and how the valuation report by the Valuer General in respect of the Motukea Wharf in 2014 impacted the valuation of the POM Port in 2015 that then was the subject of a condition precedent in the loan agreement between BSP to then finance the acquisition of the POM Port and in turn the Motukea Port and subsequently the construction and development of the Motukea Port. So we undertake an analysis at paragraph B, commencing at paragraph 14, Commissioner. Evidently, the sheer magnitude of the POM Port relocation project generated a complex commercial and financial structure as it comprised of 6 separate but related transactions, which I've described as a POM Port relocation transactions. They were as follows, Commissioner. A, IPBC acquired from PNG Ports Corporation the Port Moresby Port, located at Fairfax Harbour, for just over 710 million kina pursuant to a contract of sale of land dated 1 July 2015. And that date is quite crucial. I'll come back to that in terms of the other documents or transactions that related to that particular date. And again, you see, secondly, the second transaction from 1 July 2015, IPBC leased the POM Port back to PPCL, PNG Ports, for 1 kina annually until the Motukea Port was developed. Thirdly, again on the 1st of July, PNG Ports acquired the Motukea Wharf for 725 million kina from Barrymore No. 39 Limited, pursuant to the port sale agreement dated 28 October 2014. Fourthly, IPBC financed the POM Port acquisition under a 800 million kina debt facility or a loan, essentially, to finance the three transactions that I've referred to above. And that was also dated the 1st of July 2015. Commissioner, subsequently, following a tender process that commenced on 1 June 2015, so a month earlier, PNG Ports engaged Curtin Brothers, Papua New Guinea Limited, which had been done on 22nd, which ultimately had been rather engaged on the 22nd of December. So the tender started on the 1st of June, and by the 22nd of December of that same year, Curtin Brothers was engaged to basically construct and develop the Motukea port. And that was for the sum of over 269 million kina. And finally, Commissioner, the relevant transaction that we say is important is obviously the PNG Ports financing the port development under the separate 300 million kina loan BSP facility obtained on the 26th of November 2015. So that facility was obtained just a month before Curtin Brothers was engaged to construct the port. Paragraph 15, Commissioner, the POM Port acquisition, POM Port leaseback, and Motukea Port acquisition, which are essentially acronyms I've included there, which I now describe as the port's transactions for ease of reference. Commissioner, were all completed, and this is important, Commissioner, completed and simultaneously on 1 July 2015, pursuant to the terms of the acquisition loan. And now I've done a flow chart which I'll take the Commissioner through in terms of explaining the importance and significance of that. Now, Commissioner, moreover, the POM Port acquisition and Motukea Port acquisition both had special conditions. So there's special conditions including, in particular, a subject to finance clause, and hence the importance of the port's acquisition loan. Commissioner, the significance of the port's acquisition loan to the entire Port Moresby Port relocation project cannot be overstated. This view was expressed in an email response from PPL, PNG Ports lawyer, Mr. Ryan Warokra of Alliance to Ballymore, dated 6th May 2015. This is just over a month before the settlement of the port's transactions that occurred on the 1st of July, in which he highlighted the importance of the loan for the project. Thus, and I've quoted, only once our client completes the sale of the POM Port land and receives the sale proceeds will it be in a position to settle under the port sale agreement. Now, Commissioner, for this purpose, it is important to examine the key terms of the port's acquisition loan, noting that one of the conditions precedent of the port's acquisition loan was the valuation of the POM Port by the Valuer General. So, Commissioner, before the port's loan could be entered into before finance could be advanced to IPBC under the loan, there had to be a valuation obtained by IPBC in respect of the POM Port. And I've summarized the importance of that in paragraph 19, where I say, in summary, the port's acquisition loan facility basically provided for facility A and B, the purpose of which was to finance the acquisition of the POM Port, the repayment of existing debt of 72.5 million kina, the deposit for the Motukea Port, payment of interest and fees, equity injection to PNG Ports to complete the Motukea Port acquisition, and the payment of applicable statutory and administrative fees. Now, I've stated there also that the port acquisition loan was also set out various conditions precedent listed in Schedule 2, which I'll take the Commissioner through, one of which was the valuation. Additionally, IPBC as borrower was required to procure that PNG Ports had sufficient funds available for the completion of the Motukea Port acquisition and would not make any changes to the direction to pay without the prior written consent of BSP as the agent. Now, Commissioner, I've set out a paragraph through the relevant key terms of the port's loan, port's acquisition loan. If I can take you through over the next page, page 7, you'll note, Commissioner, there's the term, the initial valuation. It means the initial valuation of the borrower's interest in the properties by the initial valuer supplied to the agent as a condition precedent under this agreement on or before the first utilization date, and which is addressed to the finance parties. The next definition, initial valuer, means the valuer general of the independent state of Papua New Guinea. And then there's also Motukea Port, which is described, Motukea Port acquisition, which is defined. The property, the subject of the initial valuation, is described as obviously the POM ports. So if you have allotment 21, section 26, allotment 8, section 53. Then over the page, valuer is defined as the initial valuer for the purpose of only the initial valuation. So that initial valuation, Commissioner, was in respect of the POM port, not the Motukea Wharf, but it was in respect of the condition precedent was for the IPBC to obtain a valuation for the POM port properties. And that's an important point I'll come back to, Commissioner, in explaining the commercial context and importance of the Motukea loan Motukea valuation when I come back to that. Now, Commissioner, I've set out the purpose as well. That's basically extracted from the loan document. Obviously, the loan document will speak for itself, but I've just basically extracted these relevant provisions for purpose of demonstrating our submission as to the importance of the Motukea Wharf valuation that impacted on the POM port valuation that was the subject of the condition precedent for the loan. And I've set that out there over at page 9 and page 10, Commissioner. And you'll see at the bottom of page 11, or rather at the top, you'll see the last condition precedent, number 6, valuation and survey. Our condition precedent was a copy of the initial valuation, which has been defined and which I've taken, Commissioner, you through earlier. Now, what does that all mean, Commissioner? And this is what the analysis is. As observed above, the POM port valuation was primarily assessed on the Motukea port valuation. So there was an earlier valuation on the 23rd of September 2014 by the Valuer General. Now, there's a point of contention there as to which valuation was the correct valuation, but I'll just leave that to the side. There's a valuation, or there are two valuations that is a point of contention, but they're both dated the 23rd of September 2014. Now, at the core of the port's acquisition loan, that's the loan that BSP financed to IPBC, that was dated the 1st of July 2015, Commissioner. And at the core of that lay the POM port valuation as per the condition precedent. And that valuation was dated the 15th of March 2015, and my friends have essentially put that into a working copy bundle of documents, which I'll take the Commissioner through as well. Now, Commissioner, the provision of this finance facility was very important to the POM port relocation project because it effectively bankrolled or enabled the completion of the transactions. Without the loan facility under the port's acquisition loan, the POM port project would not have been possible. There had been agreements signed, NEC decisions made, valuations done, but it all came down to a question of finance. And the question of finance had a number of conditions precedent, one of which was the POM port valuation. Now, it is important to note, for the purpose of the port's acquisition loan, Commissioner, there was reference to the Deloitte valuation and the Ernst & Young valuations. Now, Commissioner, we say they are irrelevant for purpose of our submissions in terms of the port's acquisition loan. The reports were also outdated in any event. They were done in 2013. They were heavily qualified, and they did not in any event give an accurate, fair market valuation of the Motukea port. Now that comes back to the issue about the evidence of the Valuer General, which I'll come to a bit later. So, Commissioner, it is in that transactional context that the Commission is urged to consider the profound impact the Motukea port valuation had on the POM port valuation, and in turn the port's transactions, and ultimately the outcome of the POM port relocation project. Now that leads me to the evidence of Gabriel Michael. We've focused our submissions, Commissioner. There's not much contention on the factual matters that my friends have touched on in their submissions, but to the extent that our submissions are different or are in contradiction to their submissions, we essentially adopt our submissions commencing at page 12 to the extent of any inconsistency in their submissions. And this is essentially the crux of our submissions as to why we say the evidence of Gabriel Michael is very important in considering the commercial context of the whole project. Now, Commissioner, and I've stated that it is submitted contrary to the submissions dated 24 March 2023 that the Commission find that Mr. Gabriel Michael's evidence was relevant and admissible as to the circumstances surrounding the valuations of the Motukea Port and the Palm Port. So there were two valuations, one for Motukea Port, one for Palm Port. Mr. Michael's affidavit was, in our submission, properly adduced into evidence in compliance with the principles of natural justice, particularly in circumstances where no objections was raised by Mr. Evore of Ashurst, who was present during the hearing. Now, Commissioner, furthermore, for reasons only known to themselves, Curtin Brothers Holdings NG Limited and Ballymore No. 13 Limited elected not to cross-examine any witnesses, including Mr. Michael. Now, Commissioner, it is our submission that as a matter of procedural fairness and natural justice, pursuant to Section 59 of the Constitution, it is submitted that the ruling Brown and Dunn is applicable to the consideration of Mr. Michael's evidence, as it is clearly a point of contention. So there is differing versions of what my friends are submitting as being the correct version, and there's a different version we say is the version that should be adopted should be found by the Commission as being the correct position. Now, Commissioner, we submit that the submissions made by the lawyers for Curtin Brothers and Ballymore as to Mr. Michael's version of events should be dismissed. We say that you should disregard any submissions, particularly when none of those matters were put to him to afford him an opportunity to at least explain or respond to those matters that they now wanted to submit on as to what the position was in terms of what the factual, what had happened as a matter of fact. And we've cited there the case of Bank of PNG versus Marshall Cook and the case of Gelu and Stephen, both national court decisions in support of this proposition. Now, Commissioner, again, contrary to the submissions dated 24th March 2023, the Commission is urged to find that Mr. Michael Gabriel was a credible witness and accept his evidence in its entirety. Commission, having regard to the hearings, transcripts, and exhibits tendered into evidence, it is submitted that Mr. Michael was credible because of the following factors. And we've attempted to address these in terms of what the ordinary principles that have been applied and adopted in this jurisdiction, Commissioner, in terms of considering the demeanor of the witness. In this instance, we referred to the case of Tuhi against the State, PNG Law Report 1990, page 229. Commissioner, Mr. Michael exhibited a good demeanor when giving evidence as he appeared confident, honest, and forthright. Secondly, Mr. Michael conducted himself admirably by availing himself on numerous occasions to be further examined or cross-examined on his evidence, even after he was no longer the Valuer General and had relocated his residency to Mount Hagen during the 2022 national general elections, where he was an unsuccessful candidate. So that's the first point we wish to make in terms of his demeanor. In terms of his conduct or his prior conduct, Commissioner, relying on the case of State against Kuma, 2009 PG NC 290, we say there is no evidence that Mr. Michael had engaged in improper conduct on a previous occasion or was notorious in that regard, except for his own admission that the 410 million kina Motukea port valuation was true and correct, whereas the 725 million kina Motukea port valuation was false. So that was the only point at which there was evidence that he himself gave, which he effectively incriminated himself. Now, and we say there was no suggestion, no evidence prior to that of any misbehavior or any disciplinary action or any suggestion that he was not someone that had a good track record, so to speak. The third point, in terms of consistency, Commissioner, we rely on the case of, again, Tuia and the state, and also Kekedo and the state. And the citations are there, Commissioner, for you to consider. Commissioner, the variance as to the ones, so there was my friend took it to the valuations and demonstrated there was a spelling mistake and there were 2 grammatical errors in the 410 million kina Motukea port valuation in comparison with the 725 million kina port valuation for Motukea, and he essentially submitted it because in his submission there were those errors that were corrected, or apparently corrected in the subsequent valuation, that there was inconsistency in terms of his evidence, and therefore his evidence should not be believed. Now, Commissioner, just to demonstrate the point, my friend did acknowledge in his submission that it was obviously a word processing issue. None of these matters were put to my friend, and I then re-emphasized the point about the need or the failure of my friend's clients to put the specific question to the witness. He was available. He did turn up to attend and answer any questions. He was under summons, but he did attend, and none of these matters were put to him. And so, to the extent they were not put to him, those matters, Commissioner, we say should be rejected for that reason alone. But having said that, we say those errors are not material, Commissioner. And I'll demonstrate that there's another spelling mistake at page 2 that appears in the 410 million kina Motukea port valuation that my friend was obviously demonstrating as an example, but there was also another example in that same valuation, the 410 million kina valuation, where the word, as I stated there, its properties are zoned, appears in both the Motukea valuation and also the Pom Ports valuation. So these are grammatical errors, we say, which are insignificant. And there should be no bearing in terms of affecting the credibility of the witness. And therefore we say, consequently, these mistakes are essentially cosmetic or insignificant, to the point where no weight should be placed on them in the way contended for by the submissions of my friends. Now, Commissioner, if I can ask that the exhibit Ballymore-27, it was essentially in the a bundle of documents that were produced to the Commission earlier. There were 2 tranches of documents, you'll recall, that were produced by Ballymore under summons. This is under the first tranche, described as 27. If they could just be pulled up to the screen, Commissioner, so I can just take you through to demonstrate the importance of this document in terms of what I'm trying to explain. So, Commissioner, this is a document that was produced and turned into evidence by Ballymore and marked as Ballymore 27. And I'll come to that in terms of the differences between that valuation document and the valuation document that appears in Mr. Gabriel Michael's evidence that is also in the working bundle. But essentially, I note there, Commissioner, that that document appears to have only 1 spelling and 1 grammatical error. And I'll take, Commissioner, take you through that. Perhaps if you can scroll down. So this is the valuation document that was produced by Ballymore, Commissioner. So the first page, second page has the valuation amount, 722 million kina, plus. Then you have the date, 23rd September, 2014. And Commissioner, you note there that it states, this valuation report has been prepared in accordance with the client IPBC request for market valuation of the property legally described as portion 2991, apart portion 2893, Billings Granville, 4 Mill Mosby National Capital District, dated 25th August 2014. This report has been prepared for the private and confidential use of the client to whom it is addressed and should not be reproduced, either wholly or in part, or relied upon by third parties for any use without the express authority of the Valuer General. It goes on to state the purpose of the valuation. The purpose of this valuation is to ascertain the fair market value of Part Portion 2893, Motukea Port Facility, and Portion 2991, underwater lease for the Future Port Project, PFPP. And it explains the basis of the valuation. I'll come back to the importance of that statement, Commissioner. But I wanted to demonstrate, I'll just locate the relevant page, Commissioner, where the error appears in terms of just demonstrating the insignificance of the errors. So if your Commissioner opens at tab page of the working copy, Commissioner.
Yes.
And the point I'm trying to emphasize here, Commissioner, is that the typographical errors are insignificant. That's essentially what I'm trying to demonstrate here in our submission. So if you look at, it's on page 128 of the working copy, 138, Commissioner. Okay.
Yes.
Yes, Commissioner. And in our document B27, it should appear. It should appear on page 10. So if you could scroll down to page 10, please, at the bottom of page 10, under the heading Valuation Methodology. So if that could be just zoomed in, please, to the valuation methodology. And you can see there, Commissioner, that direct comparison approach. So you can see that there's no typographical error, Commissioner. Can you see that? Now you look at the document, page 138.
Yes.
Can you see there, Commissioner, the word "the" directly separate? But then when you come to the next two words, comparison approach is one word. Can you see that?
Yes.
Yes. So the point I'm trying to make there, sometimes documents do get jumbled up in the word processing. And obviously, there's a version that's been produced by Ballymore that they're relying on because they produced it on the summons. It's called a typographical error. The one that's been referred to by the Valuer General in his evidence does not have that error. So the point is little or no value or weight should be given to any discrepancy in terms of typographical errors. However, that's different in terms of numbers and figures and value. That's the point I'm trying to make, Commissioner. So we'll just leave that for the moment, Commissioner. Now we move on to bias or no bias, Commissioner. And this is important. We say, relying on the cases cited therein, Commissioner, at page 14, no evidence that Mr. Michael has a personal interest in the outcome of the case. There was no evidence of that at all. There's no reason to doubt his dishonesty or to affect his integrity. Mr. Michael, again, conducted himself appropriately and was compliant in every respect in terms of assisting the Commission to the point where he actually gave evidence that incriminated himself. Now, one ordinarily would not give evidence that would incriminate themselves, but he did so, Commissioner, noting that Section 13 of the Commissioners' Inquiry Act does protect him in that regard. And it's important to emphasize that provision, Commissioner. That provision essentially protects or allows, if I can read that section, Commissioner, Section 13 reads, statements by witness not admissible in evidence against him. So it reads, a statement or disclosure made by a witness in answer to a question put to him by a commission or by a commissioner is not, except in proceedings for an offense against this act, admissible in evidence against him in any civil or criminal proceedings. So essentially, this provision allows a person who is otherwise not in a position to give evidence that would be adverse to him to be able to give an opportunity to present such evidence. It gives him that comfort to provide evidence, perhaps the facts that related to this particular project. Now, Commissioner, corroboration, there was much in the opening of the submissions. My friend reminded you, Commissioner, to verify the facts or refer to some form of independent source documentation in the, apart from the evidence of the valuer general as to his credibility. So we attempted to examine other relevant evidence that impinge upon or otherwise say that the evidence given by Mr. Michael is corroborated by other independent evidence. And we demonstrate that by reference to the exhibit that I've just called up, Exhibit Bellimo 27. And why I read out the opening statement about the purpose and who the client was, Commissioner, this document that came into the possession of Bellimo is a confidential document. It was solely to be intended for the use of IPBC, who is recorded as the client at page 1, paragraph 1, under the heading Valuation Instruction and Terms of Reference. So that goes to show that there was evidence given by him saying that there was a meeting between him and one Justin McGann. He essentially, that is a point that's been disputed by Bellimo. Mr. McGann has not, although someone has not participated in this commission, we have requested the lawyers for Bellimo and Curtin Brothers to confirm whether they have instructions. They do confirm that they do not have instructions to act for Mr. McGann. He is a director of Bellimo. He signed off on correspondence for Bellimo in respect of the process in relation to the negotiation, acquisition, and documents as to the PSA or the port sale agreement and other related documents. So he participated in this, and there's been no explanation why he has not come forward to simply tell the Commission whether he had a conversation with Mr. Michael or he did not. If he did have a conversation, what was said? Simply like what Mr. Kilapat did. He attended, he gave his side of the story. We do not accept his explanation, Commissioner. Mr. Secretary was not the employer of the Valuer General. The Minister for Lands, who is incidentally a member of the NEC, is the employer in that regard in terms of hiring and firing a Valuer General under the Value Act. And now, Commissioner, if we can scroll down right down to the end of that valuation document. To the last page, please.
Yes.
Yeah, right to the end, please. Yeah, that's the last page. Now, Commissioner, that's the last page of the document. Now, I take you back to the same working copy of the bundle, Annexure H, Commissioner. Now there are a couple extra pages in. So you come to page 145 of the working book, Commissioner.
Yes.
144 rather, and you'll see the same photograph that appears on the screen, Commissioner. Do you have that?
Yes.
Now, Commissioner, that's the last page of the document, Ballymore 27. Now, if you turn over the page, this is the valuation copy of Mr. Gabriel Michael, page 145. Do you see that, Commissioner?
Yes.
And more particularly, page 146 and 147.
Yes.
Yes. So that is obviously a different document. And this is our submission as to why it is a different document and why it corroborates Mr. Michael's evidence. In our submission, Commissioner, if you look at the bottom of the page, it says state lease, and you'll see the, Commissioner, pages 34 of 46, and it says PSA 060814. Do you see that, Commissioner?
Yes.
Yes. Similarly, over the page, well, sorry, back, that's page 147, but 146 is essentially the same narration. Now, Commissioner, I'll take you through to paragraph D of my submission at 15. The significance of that is very important because this actually corroborates what Mr. Gabriel Michael says, in the absence of any evidence to the contrary. So disregarding Mr. Kilapat's evidence for the moment, we're looking at a document produced by Ballymore 27, their own document that they're relying on. And we're comparing and contrasting it to this document. Their document does not have these pages. And this is the reason why, Commissioner. This is the reason why it is contained in Mr. Michael's evidence. This is our submission. If the Commissioner looks through, there was a second batch of documents. A thorough review of the second batch of documents produced by Ballymore reveals that Ballymore adopts this page and document referencing style. So there were a number of draft contracts that were exchanged between Ballymore. They were actually initiated by Ballymore's in-house lawyer, and they were sent through various lawyers acting for the other parties. And at the bottom of those documents, you'll see the same page referencing style. And I've specifically referred to that, Commissioner. So you've got the first one. You've got Ballymore Trench 2-9. Then you've got Trench 2-12. And I put in brackets there, Commissioner, template with 38 pages, but same, dated 060814. There's also the Trench 2-31 that has the same referencing style. There's a Trench 2-307, Trench 2-311, Trench 2-317, Trench 2-330, Trench 2-352, Trench 2-363, Trench 2-381, Trench 2-418, Trench 2-448, Trench 2-457 and 459, Trench 2-465, Trench 2-472, Trench 2-479. Commissioner, in those circumstances, the Commission ought to find, in the absence of any plausible evidence or reasonable explanation to the contrary, that Ballymore is the author of such a document. Consequently, the existence of these two state lease documents, adopting this peculiar page and document referencing style in Annexure H to Exhibit VG1 to corroborate Mr. Michael's version of events as to his meeting with Mr. Justin McGann, a director of Ballymore and general manager of Curtin Brothers. These Ballymore Trench 2 exhibits identified above are effectively the missing link that corroborate the meeting between Mr. Michael and Mr. McGann. He says he met him. He was told to increase the valuation, and lo and behold, this is a confidential document that's supposed to be only produced to IPBC as the client, somehow finds its way into a bundle of documents produced by Ballymore. And there's no explanation as to how the document came into their possession. Absolutely none. Now, Commissioner, I then now turn to Mr. Kilapat's evidence. His explanation, we say, is baseless because the Minister for Lands and Physical Planning determines the appointment of the Valuer General, not him as the secretary. This is another good reason to give more weight to Mr. Michael's evidence over Mr. Kilapat's. Mr. Michael's perception that his position was in jeopardy is well founded in our submission. This is having regard to the following considerations, Commissioner. You look at paragraphs 180 of the submissions. So Mr. Michael would be defying effectively the National Executive Council, to which his master, the Minister for Lands and Physical Planning, is a member. If you look at Section 2 of the Evaluator General's Act, the Minister is the relevant appointing authority. And we've referred to also the implied power to alter of the Interpretation Act and the relevant cases that deal with the exercise of that provision. That's at page 16, Commissioner. And we also look at, refer to Section 138, vesting of the executive power, Section 139 of the National Executive, Section 148, functioning, etc., of ministers of the Constitution of Papua New Guinea. So, Commissioner, another matter that corroborates is the law. The law is contrary to Mr. Kilapat's evidence. Mr. Kilapat's evidence is baseless. What had happened was there was a NEC decision made before evaluation was done. He had to comply with the direction, Commissioner. Otherwise, he'd be out of his job. It's simple, and that gives credence to why he said he did what he did. And it's more important, Commissioner, because it emphasizes the next point. If you look at the Annexure A in VG1, he was appointed on the 18th of February 2014. This is just 7 months prior to the Motukea Evaluation Report of 23rd September 2014. Noting his appointment was revoked on 6th April 2017, and then he was reinstated on 4 April 2018. Now, if you look at the that's annexure in the working copy, Commissioner. So if you look at Annexure A, is the relevant instrument. Do you have that, Commissioner? Page 26. So this is just an example of the power to essentially hire and fire the Evaluator General. It's not the Secretary of Lands. It's the Minister, and this just confirms that this is just an example of the instrument under which Mr. Michael was appointed. So quite easily, this was done on 18th February. There was an NEC decision in about June, July, one of which was rescinded, and the other one was endorsing and directing effectively the approval of the LOI and other documents related to the Motukea transaction. He effectively received a letter from the IPBC Managing Director to do an evaluation. He did an evaluation in our submission for 410 million odd. He produced that to Mr. Kilapat. For some reason, he was not happy with that. He then received a call as well from Mr. McGann in our submission from the evidence that I've taken you through. At that meeting in our submission, that's how the document that I referred to in terms of the state leases found its way into his own valuation report, which is not in the valuation report produced by Ballymore. These are all matters that corroborate Mr. Michael's story, Commissioner. Simple as that. We'll now move on to motive, Commissioner. So for those reasons, Commissioner, there was no motive. There's no evidence or submission been made for Mr. Michael's motive to give false evidence. He's got nothing to gain. He's got everything to lose in terms of his integrity. And that's the very point that my friend emphasized, that he should not be believed because he essentially produced two reports, one of which was for 100 million plus, and one was for 700 million plus, and he should not be believed. That was the submission. And my submission, Commissioner, is that's all the more reason why his evidence should be believed. If there's anything, if there's anyone who's lost in this, it's the Evaluator General in terms of his integrity. But he's done the right thing to clear his conscience, to come to this commission under the protection of Section 13 of the Inquiry Act to give his version of the facts, knowing that he will not be prosecuted per se in terms of giving his evidence unless there is a recommendation made to that effect if it is so in fact made by you as the Commissioner in your report. And we've also emphasized the maximum penalty for 14 years prison sentence if someone is found to be effectively giving false evidence. So, Commissioner, it just comes back to now the crux of our submissions at the end, the paragraph D, the consequence of evidence by Mr. Gabriel Michael. In view of the reasons submitted above, Commissioner, we urge this Commission to find that in all the circumstances, the Valuer General's conflicting valuation reports was due to the pressure that was brought to bear on him by the Secretary for Department of Lands, Mr. Romney Kilopat, and Justin McGann, General Manager of Curtin Brothers and the Director of Ballymore. Therefore, the 410 million kina plus Motukea valuation was the correct valuation, and the 725 million kina Motukea port valuation was false, based on the evidence of Mr. Michael. Consequently, the Commission in our submission should find that the 725 million kina Motukea port valuation was false and was falsely increased by 303 million plus. Accordingly, in our submission, Commissioner, inevitably follows that the fair market value of the POM port valuation was incorrect. My friend took the Commission at length to emphasize that Mr. Gabriel Michael had relied on his earlier valuation of the Motukea port to form the basis of his assessment for the fair market value for the POM port valuation, which then formed the condition precedent. And, Commissioner, in that regard, the POM port valuation was incorrect, which ultimately caused the state, through IPBC and PNG ports, to effectively obtain a loan well in excess of the true value, thereby causing financial losses, not only to the state, but the taxpayers of this country, Commissioner. Now, we've set out in the conclusions effectively, again, grateful for the submissions that have been produced in respect of the individual terms of reference. But again, we make that subject to the overriding submissions we've made in terms of the findings and effect of the evidence of Gabriel Michael, Commissioner. And at this point, Commissioner, just to demonstrate the importance and the commercial context of us that the three diagrams will be called up onto the screen, Commissioner. I've had these emailed to my friends. I'll hand up a copy, Commissioner. Commissioner, the first diagram is a commercial, yes, that's right. So that's the one with the Valuer General. So it's sort of in a cogwheel, Commissioner. There's two cogwheels. Effectively, the orange relates to the Valuer General's evidence, Valuer General's valuations. We're just trying to show the relationship of the structure I mentioned earlier, and this is essentially a snapshot of what occurred. Sometimes it's a bit difficult to understand when there's a lot of documents. In some instances, 100 pages of documents can be essentially summarized in one particular page by way of a diagram, Commissioner. And this is to demonstrate the significance of the Valuer General's report, Commissioner. So you'll see there in orange, in the cogwheel, Valuer General's cogwheel is basically has 2 points: the valuation of Motukea Port and valuation of POM Port. And there's an arrow looping around to the, in this instance, the IPBC transaction. So effectively, it was only the POM, it was the Motukea Port that was valued first, 2014, as you'll recall, Commissioner. And then that formed the basis of the valuation for the POM Port. and I took you, Commissioner, through the conditions precedent. So only the valuation of the pond port was then the document or the valuation that was used by IPBC and BSP to enter into that loan facility. Now that then became, that you can see the arrow then pointing across to IPBC, or, the point of this whole diagram is to show that everything flowed from a flawed, false valuation report by the Valuer General, which he clearly admitted to, and was not cross-examined, or there was no plausible alternative as to why he did that. And in our submission, he did that essentially in good conscience to clear his conscience. And everything flowed from that. Everything flowed from the false, in our submission, Motukea Port valuation in 2014. That formed the basis of the pond port valuation. That then formed the basis of the loan acquisition. It then formed the basis of the settlement of completion of all the transactions, the pond port, the Motukea Port. Although it was signed in 2014, it wasn't completed until 1 July 2015. So the dates are very important, and that's why we emphasize the commercial context under which the facts must be considered. It's not a matter of just considering the facts, Commissioner, it's understanding the whole matrix of the facts and how it relates to the actual transaction. It was essentially a loan that funded all this. And that loan was based on a valuation that was based on another valuation that was not correct. Now, the last diagram, Commissioner, is so we'll put the cogwheel diagrams aside and just pull up the flow chart, if that's the correct term. And it's just another way of looking at it, Commissioner. So just a play with a design in terms of trying to explain the relationship of the Valuer General's report to the conditions precedent under the BSP loan, to the IPBC, and then to PNG Ports, Ballymore, and obviously Curtin Brothers, and the amounts and how that was all structured. And that's important to understand it in that context. That's what we wish to emphasize, Commissioner. That is the lens through which your findings must be based. It must be it must be seen through the commercial context, not simply the factual context. Yes, you take into account the factual context, but there's also the commercial context. And then you'll understand that the Valuer General's evidence was not irrelevant, it was absolutely critical. Absolutely critical. Now, Commissioner, you can have a look at the submissions on the recommendations, but we effectively adopted pretty much all the terms of reference and the recommendations made therein. The point I wish to make on the last page of our submissions, Commissioner, term 1G, you'll see the paragraph 59, Commissioner. It's the last page of the submissions, page 25. Basically, in closing, Commissioner, that's obviously, Commissioner, there may be other statutory and regulatory recommendations you may wish to look at in terms of forward thinking, in terms of making sure something like this doesn't happen again in terms of future valuations. But for purpose of hindsight, in terms of the evidence, we formed a view and we submit in our respectful submission based on the evidence that's before this Commission that at paragraph 59 we've mentioned, we state quite clearly that Ballymore number 39 Limited and Mr. Justin McGann be referred to the Royal Constabulary of Papua New Guinea for investigation for fraud. That is our submission, Commissioner. And that's the point we wish to make known. Otherwise, Commissioner, those are our submissions unless you have any further questions.
Thank you, Counsel. That's the response to the earlier submission by the Curtin Brothers in Ballymore number 39, which was submitted earlier on the 31st of, earlier on to the Commission. We shall return back on the 14th of April, 13th of April, to deal with the submission by the landowners. That should allow time for Kate and Brothers to have a look at the submission, the detailed information. And then on the 14th, we return back at 10 a.m. on Friday for Kate and Brothers to respond to the Counsel assisting the Commission submission in terms of facts, commercial evidences, and the general evidences that will be dealt with on the 14th of April 2023 at 10 a.m. when we return back. I will look at the submission by the Counsel assisting, and I have also gone through the lengthy submission by the Kate and Brothers, Baltimore 39. There was an observation that I noted, and that is on the page number 94 of the submission by the Kate and Brothers on the term of reference 1/D. And I read on point number 286, if you are following, where it says the scope of the reference 1 DDDD is determined not only by the words of 1 DDD, close bracket, but also by reading in context with the remainder of the amended terms of reference and the COI statement of case. The words must be considered in the context of terms of reference as a whole. That gives me some of my views as a commissioner to look into that, but I know that it has been addressed, but if this statement of case and the amended terms of reference provided a broader view of what is expected, that it needs to be demonstrated to the Commission, to the specifics of what is needed. That is one of the observations that the Commission looks into. And that also backs up the earlier statement, which I always repeated, that facts of evidence must be properly evaluated, examined, and provide clarity into the flow of what is before us. This is a kind of demonstration that the Commission would need. And if we are not going out of the terms of reference, it must be fitted into what it is stated on the amended terms of reference that the Commission is relying on. That is a simple observation, and I know that both counsels assisting and our friend from the Kate and Brothers, Mal and company, will look into that to assist the Commission. But having said that, the response to your submission has been completed, and we shall return back on the 14th with a response from, sorry, we shall return back on the 13th. 13 is the landowner submission, providing that Ketan Brothers have enough time to have a look at the document, and then we'll return back the following day, which is the 14th. With that, thank you for your attention this morning, and until we return back, as I said, you can now adjourn the hearing to the 13th, which is Wednesday next week. Sorry, I have to correct myself. We return back on the 13th, which is Thursday, to deal with the landowners, and then following that will be the response from the Ketan Brothers, which is Friday the 14th. Thank you, Counsel. You can now adjourn the hearing.
This Commission of Inquiry is now adjourned.